Hey, this is Jeffrey Blair, estate planning attorney in New Jersey, and here are 5 estate planning essentials you can't afford to ignore in 2025. With the new civil year, it's a great time for you to start thinking about your estate plan. If you have one, to review it and make sure that it's still relevant to your life circumstances. Maybe you got married, maybe you got divorced, maybe you had children, maybe you bought a house. You want to make sure that you have things in order. So here are 5 questions you need to ask yourself now that we've started this new civil year. Question number 1, what happens if I don't have a will? Well, if you pass and you don't have a will, then your assets would go through a process which is called probate. And in probate, the state will make determinations about, number 1, who's in charge of your estate, number 2, who gets your assets according to their own formula. So if you don't have your own plans in place under a will, then the decisions that the state makes may not be in line with what you want. So it's important that you have a will. Number 2, what happens if you don't have a power of attorney? If you become incapacitated without a power of attorney, then no one will automatically be able to access your finances. No one could go into your bank account and be able to pay your bills or be able to process your paychecks or anything like that. A power of attorney gives someone that you trust the power to be able to step in if you're not able to, be able to take care of your financial affairs and make sure nothing gets fallen through the cracks. Number 3, what happens if you don't have a healthcare directive? Without a healthcare directive, your family may face difficult decisions just in case you become sick due to illness or injury. With a healthcare directive, you're instructing your family, these are the things you want to have happen just in case something like that happens to you. And that will alleviate a lot of confusion and also allow people and family members to understand what it is that you want to have happen in case something like that takes place. Number 4, what happens if you have a home, but you don't have it in a trust? Without a trust, your home may go through a probate process, and the process can be time consuming and also will have the state involved. It will become a public process. Having a trust allows that home to be placed into that trust so that you'll be able to pass it on to your beneficiaries without any type of public officiating over it or any type of state interaction. Number 5, what happens if you have minor children and you become incapacitated? If you're unable to care for your minor children due to illness or disability, and you haven't named a guardian in your estate plan, well, then the court will have to step in and go through a process of instituting a guardian or conservatorship for your children. And that can be costly, it can lead to delays, it can lead to confusion with family members as far as who's going to be taking care of the children and how's that going to take place. All these things can be taken care of if you just take a few minutes to create an estate plan to lay out this ahead of time and to have you and your family have peace of mind. It's a new year, so we can get started with this. We can simply go through the process, and I'm here to help. Jeffrey Blair, estate planning attorney.